My name's Sandra Worthington. I'm a personal injury lawyer, and I've been practicing for over 30 years. Clients come into my office, and some of them have discussed their cases with adjusters on their claims, and they want to know what the adjuster really means when he says something. So when, for example, the adjuster says X, what does he mean? Well, I can tell you he really means Y. Let's look at 4 statements the claims adjuster might make in conversations with you to learn what the adjuster really means and how you should respond. Number 1, when the adjuster says, I'd like to take your statement, what he really means is, I want you to commit to one version of what happened right now so that I can use it against you if you try to change your story later. Adjusters are paid to investigate claims and gather facts. The linchpin of their investigation is your statement. And believe me when I tell you, the adjuster will try to get you on the phone or in person as soon as possible after the accident. Why? Symptoms often get worse in the 24 to 48 hours after an accident. They want to catch you while you're still in shock or before your symptoms really set in. The adjuster will use your statement to A, commit you to a version of what happened, B, question your credibility if you correct an innocent mistake or add an overlooked detail, C, look for interpretations that reduce your claim's value, D, disprove injuries that you have suffered which worsen after the statement is given. Number 2, when the adjuster says, please sign this medical authorization form, what he really means is, please sign this form so that I can gain access to your entire medical history going back to the womb and perhaps find something I can use against you. Adjusters frequently ask claimants to sign a medical authorization. This gives the adjuster permission to obtain copies of your medical records. The problem is that most of these insurance company authorizations are broadly drafted and give adjusters the ability to delve into a claimant's complete medical and psychological history, as opposed to just obtaining records related to treatment for the accident itself. This allows the insurance company to pry into pre-existing conditions and medical or psychological issues that may be completely unrelated to your claim. Most claimants who do not have a lawyer will sign these medical releases innocently because they think that if they cooperate with the adjuster, this will increase their chances of getting a prompt and fair settlement. 3, when the adjuster says, why do you need an attorney? I'll work with you on the claim. What he really means is, please don't call an attorney. When an attorney gets involved, it becomes much harder for me to push you into a fast, cheap settlement. When the adjuster deals with an unrepresented claimant, the adjuster has the upper hand because he knows how the system works and he has been trained in negotiation. Once a personal injury attorney gets involved, the adjuster loses his advantage. As a result, to discourage you from contacting an attorney, the adjuster might say, your claim won't be any more valuable just because you get an attorney. This is also false. The price tag of a claim almost always goes up when an attorney gets involved. Or he might say, why do you need an attorney if I'm looking out for your best interests? Well, that's just not true. The adjuster is actually seeking the opposite. He wants to pay you as little as you will accept. In fact, he doesn't want to pay you a dime. Or he might say, if you get a lawyer, we will have to hire one as well to take your deposition. Well, that's true, but if the case proceeds, then a deposition is nothing to fear. You're merely giving your statement in person with your attorney at your side. Or he might say, if you hire a lawyer, it will slow down the claims process. Well, this is true, but it is also likely to result in a much better outcome. Number 4, when the adjuster says, if you don't accept this amount right now, we will withdraw all offers. What he really means is, please take this low offer so I can close your file and get it off my desk. This is often a bluff. If your case is worth $20,000 today, it will likely still be worth $20,000 tomorrow, and next week, and next month. If it's not a bluff, the claims adjuster withdraws the offer. Consider the withdrawal an invitation to file a lawsuit. So to recap, decline to give a statement. Require limiting language on any medical authorization form you sign. Understand that the adjuster really does not want you to retain an attorney. Do not fear the adjuster's threat to withdraw all offers. Compare the adjuster's last offer to your claim's value and then decide whether to accept it. If you need help evaluating your claim's value, call us to discuss it. There's never a charge to consult with us, whether you hire us or not.